to the Federalist Society National Lawyers Convention. The convention theme this year is the rule of law and the current crisis, and our panel this afternoon on intellectual property is intellectual property rights and the rule of law. My name is Judge Ryan Holt. I am a judge on the United States Court of Federal Claims and a Juris in Residence Professor of Law at the University of Akron. We have four excellent speakers for our panel today, and we will go in order of speakers by the order that I do the introductions. Our first speaker is Professor Richard Epstein, currently the Lawrence A. Tisch Professor of Law and Director of the Classical Liberal Institute at New York University and the Peter and Kristen Bedford Senior Fellow at the Hoover Institution, as well as the James Parker Hall Distinguished Service Professor of Law Emeritus and Senior Lecturer at the University of Chicago School of Law. Professor Epstein has authored numerous books and journal articles on various areas of the law, including intellectual property rights, torts, contracts, property rights, and law and economics. He is consistently ranked by legal journals as one of the most influential legal thinkers of modern times. Our second speaker is Professor George Contreras of the University of Utah's S.J. Quinney College of Law. He's a professor of intellectual property law, and genetics and law at University of Utah's College of Law. He was recently named on the University of Utah's Presidential Scholars and won the 2018 Faculty Scholarship Award. He's previously served on the law faculties of American University Washington College of Law, as well as WashU in St. Louis. He was also previously a partner at the international law firm of Wilmer, Cutler, Pickering, Hale, and Dorr, where he practiced transactional and intellectual property law in the United States and the United Kingdom. His current research focuses on the development of technical standards and the use and dissemination of data generated by large-scale scientific research projects. Our third speaker is the Honorable Karen Temple of the Motion Picture Association. She's currently Senior Executive Vice President and Global General Counsel there. She has previously served as the Acting Register of Copyrights from October 2016 to March of 2019, and then as Register of Copyrights and Director of the United States Copyright Office from 2019 through 2020. From 2013 to 2016, she served as Associate Register of Copyrights and Director of Policy and International Affairs for the United States Copyright Office. Previously, she's also worked as Senior Counsel to the Deputy Attorney General of the United States, where she helped manage the DOJ's Task Force on Intellectual Property, and has also spent several years as Vice President, Litigation and Affairs for the Recording Industry Association of America, as well as the Recording Industry Association of America, working there, and the law firm Williams & Connolly. Billboard magazine has described her as seen as being even-handed on the kinds of intellectual property issues that have become contentious in the digital age, and the Professional Photographers of America say she has demonstrated a thoughtful approach to copyright law and to the Copyright Office management overall. And finally, our fourth speaker is Mr. Phil Johnson of Johnson IP Strategy and Policy Consulting. He's currently principal of Johnson IP Strategy, which he founded after his retirement in February of 2017 as Senior Vice President and Chief IP Counsel at Johnson & Johnson. He's currently chair of the Steering Committee of the Coalition for 21st Century Patent Reform, a steering committee member and co-chapter editor of the Sedona Conference on Biopharmaceutical Patent Litigation, and a member of the board of the Manel Chemical Senses Center. Before joining Johnson & Johnson, Phil was a senior partner and co-chair of the IP litigation group at Woodcock Washburn in Philadelphia. He's played a key role in both the drafting and passage of the America Invents Act, and was subsequently appointed a member of a six-person committee formed by the director of the PTO to make recommendations on regulations to implement the inter partes review and post-grant review proceedings established by that act. So we will begin again with Professor Epstein. We will give 7 minutes roughly to each participant to make opening remarks, and then we will allow for responses and discussion between the panelists. As part of this being a CLE, I'd like to have a first opportunity to announce our CLE code for this particular panel. That code is which should show up in your screen right now. I will announce that again as we move through the panel in case you did not get it. So after our introductory remarks, we will allow the panelists to speak and raise comments to other panelists. Hopefully we'll have a good conversation from that, and then we will transition to questions and answers within the audience. For that, you will raise your chat feature hand in the Zoom window. And with that, I'll transfer things over to Professor Epstein for Professor Epstein's introductory remarks.
Well, thank you, Ryan. My microphone is working. I'd like to thank the Federal Society for inviting me to appear on this particular panel. And the subject of intellectual property law is very much in flux, so you never know from one end of the day to the other what you're going to see. But what I'm going to try to do is to frame the general inquiry of what it means to talk about the rule of law in connection with intellectual property. The rule of law, more generically understood, has two components that are associated with it. The first of these components is a kind of a procedural requirement, and the second one turns out to be a substantive requirement. On the procedural side, it turns out that virtually everybody agrees that intellectual property law, like other forms of law, requires a certain degree of regularity in the way in which the particular system is operated and goes together. And so that means what you have to do is you have to have a neutral decision maker, you have to have the opportunity to be heard, you have to be sure that the panel is going to be free from bias, there has to be opportunity to present facts and arguments of law and the like. One of the things that very much worries me about the current state of the law was the decision that was made underneath the American Invents Act of 2011 to allow for inter partes review inside the patent office. I have no objection whatsoever for having all sorts of reviews taking place before a final patent turns out to be issued. But I think the correct answer is once the patent is issued, that it should be tried in a court of general jurisdiction, district court, perhaps even a specialized Article I court. I think it's a very big mistake to try and say that the very patent office that issued these things should then be put over the judicial courts to decide whether or not its validity is to be upheld or not. What are the kinds of difficulties that are associated with this? Well, a lot of it depends upon the rules that are used to appoint the judges. And then you're dealing with an ordinary court, the rotation and anonymity is the way in which they're selected. But inside the particular agency, it turns out that that is not the rule that takes place, is that the head of the PTAB is in a position to figure out how many people you want to put on a panel, which people you put on the panel. And at least before the current officer took over, Mr. Yanku, there was also situations in which the panel had new judges added on until the result came out the way in which the director wanted it. I think in general that the power of Congress to issue patent is subject to a general constitutional limitation. And that constitutional limitation essentially says that you cannot put in a patent grant a provision which essentially undermines the jurisdiction of Article III courts to handle all of these disputes. And that was the way in which the system worked much earlier on. The McCormick case in 1898 or so gives all the detailed precedents on that. And I think that this particular form of separation may have certain kind of short-term efficiencies, but it has the long-term ability to essentially sustain and operate the system in a correct fashion. So that would be my first point. The second point I think that one has to talk about is how do you want to think about patents? I would say if we were to ask ourselves what was the biggest sort of meta question that exists with respect to intellectual property, it would be the question of self-identification. Is intellectual property to be treated as a species of property rights, or is it to be treated as something less? And so to give one illustration of this, I'll actually give two. When Paul Clement wrote a piece about this, he said, you don't want to think about intellectual property as property in the natural rights sense. What you want to do is to think about it as a situation in which the government allows you to exclude other individuals, but that has not got the sharp definition of a property right. Most notably, the rights to use and dispose of this particular patent by license and practice are going to be compromised if you don't make it into a property right, which under all standard theories, whether for intellectual property or for anything else, include not only the right to exclude, but the right to possess, the right to use, the right to develop, the right to lease, and so forth. And the only constraints that you had on these things were those from the general antitrust law, which again carried over from standard forms of property into this particular area. Another version of this is the thesis that had been advanced by, amongst others, Mark Lemway, in which you treat the patent as though it's some kind of a subsidy. And what you assume is that the government is giving out favors. And if they're giving out favors to one, they could give it out to another. They could give the favor out. They could take it back. But I think it's very, very disingenuous to think that when you're dealing with these forms of property, that they're the same thing as a subsidy that is given to the solar energy company, Solyndra, or a farm subsidy or something else. It turns out if you look at the case of Mattel against TAM, they're pretty clear that when you give somebody, in this particular case, trademark protection, it's not a subsidy, it's a quid pro quo. We give you the exclusive so that you can develop something which is going to be for the long-term benefit, not of yourself, but for the public at large. And that's exactly what happens when you create inventions. They create all sorts of benefits for the public that come sooner, and better that you have a short-term monopoly rent on the one side than no product at all. And so what you do is you keep the limited grant and you let it go. And so in my own view, the only difference between intellectual property and other forms of property is that intellectual property, at least in the patent space, has a necessary time limitation associated with it, because it turns out that the restrictions on use have real social losses, which is not the case with land and so forth. You have to figure out what the optimal period is, say something about 20 years and so forth. Within that period, you want to treat it pretty much the way you treat all other forms of property, with the strong rights that I've given and the remedial protections that are associated with injunctions and the like. You also want to make sure that when you're dealing with patent eligibility, you don't expand the notion of what counts as a common property situation, a natural substance or an abstract idea, so that all sorts of inventions take place. I can't go into this now, but I've always been a defender of the position that Giles Rich took, both with respect to intellectual property on the one hand, and with respect to medical and other kinds of inventions on the other, that they should receive these kind of patent restrictions and should not be treated as though they were a knockoff of the rule E equals MC squared. I see that my time is about up, but essentially the final message is, if you have the right set of substantive rules, the rule of law constraints become much easier to observe, because what happens is a system which has strong metes and bounds in the property space reduces government discretion, and a system that respects freedom of contract is going to be one in which the courts have the job not of setting the terms of just arrangements, but figuring out what the parties meant and then applying standard contract principles to see that those bargains are accepted, subject, of course, to the usual constraints of force and fraud, monopoly, and the like. So with that very conventional position, I think I am now turning the panel over, if I am not mistaken. Who am I turning it over to? You to Rodriguez, right? Okay, well, I'm going to turn it over, okay? Take care. And
Thank you, Professor Epstein, and now Professor Contreras.
Thank you. Thanks very much. And thanks to the Federal Society for inviting me to speak on this panel. It's a real honor, and an honor especially to follow Professor Epstein. So since the subject of the conference is the rule of law, I'm going to take a slightly different tact. And I'd like to address my opening comments to a trending narrative that casts opposition to the demands of patent holders as a form of lawlessness. This narrative specifically takes aim at a practice that has been termed efficient infringement, the idea that a firm may rationally decide to infringe patents either because it's going to be too costly for the patent holder to enforce its rights in court, or because it's happy to take its chances in court, where an asserted patent could be invalidated, where damages eventually assessed against the infringer years later will likely be no higher than the royalties that the infringer would have paid anyway under a licensing agreement. So commentators today bemoan a prevailing steal what you want attitude among large companies. One commentator explains that efficient infringement is, quote, another way to say it's okay to violate a constitutionally granted right. Another compares patent infringement to piracy on the high seas, arguing that infringers exploit the lack of enforcement of the law of nations. One writer, just days after the recent US presidential election, was quick to place the blame for the, quote, anti-patent chaos that marked large portions of the Obama administration on an enemy within, a handful of politically well-connected companies that were helpful to Obama's own political ascendancy. So among the top recipients of criticism in this narrative is the PTAB, the Patent Trial and Appeals Board, which Professor Epstein mentioned, an arm of the Patent and Trademark Office that has, it's true, rejected a large number of issued patents as invalid. In response, the PTAB has been called a patent death squad, a kangaroo court, despite the fact that, at least to my knowledge, it has generally operated within the statutory mandate established by Congress, for better or for worse. So these statements are not the ramblings of internet trolls or conspiracy theorists. These are statements that have been made by respected figures in the patent world, former government officials, judges, academics, and prolific writers and patent practitioners. And the question I pose is, are they right? Is the United States descending into a state of lawlessness in the patent area? And I do not believe that it is. So let's consider more closely the conduct that critics are responding to. When complaints of widespread efficient infringement are made, they're not generally referring to cases in which one company copies its competitor's patented products and just hopes to get away with it. Nor are they referring to cases where there's a breakthrough discovery that's made and jealous competitors race to incorporate it into their products. Nor is it a case of a licensing deal gone sour in which one company reneges on its obligation to pay an agreed price for access to a partner's technology. And it's not a case of industrial espionage in which valuable technology is surreptitiously pilfered from a competitor's servers or carried away by disloyal employees. All of those examples are indeed lawless and worthy of condemnation. But efficient infringement is something different, even though it's being cast in the same light as those other types of behavior. Here, a large operating company, often a manufacturer or service provider, is approached by a patent assertion entity, a PAE, often referred to as a patent troll. The PAE notifies the company of a patent portfolio in the general area of the company's business. It offers the company a fee-bearing license, but the company ignores the offer. The message back to the PAE is, sue me, because that's the only way I'll ever pay you a cent. And the question is why a law-abiding company would adopt this approach. Is it evidence of the lawlessness that these critics decry? I don't think so. There are numerous legitimate business reasons that a company should adopt exactly this approach when confronted by a PAE demand. First, as has already been indicated, every year a significant number of patents are found invalid, either at the PTAB or in district court. Depending on the industry, the invalidation rate can be over 50%. Thus, when a company is approached by an entity bearing patents, there are good odds that some or all of the proffered patents will be found invalid. Compounding this fact, patents held by PAEs are often considered to be of lower quality than average. Why? Because they're often acquired from bankrupt firms that did not succeed in the market, or they're sloughed off by successful firms that do not find them particularly valuable to their businesses. If these patents happen to cover a company's products, it is often a coincidence or the result of broad and aggressive claim drafting by patent attorneys. And this last point is worth spending another minute on. It's undeniable that the claims of many asserted patents, especially in the software industry, are vague and ambiguous. Patent claims do not protect certain circuit diagrams or computer code. Rather, they are linguistic constructs crafted by lawyers to be as broad and encompassing as possible. Often, they don't even describe how a particular technology works, but only what the end function or result is. So I submit that those who analogize patent claims to real property deeds haven't read enough patent claims. There are no clearly drawn boundary lines here. They harken back to the worst of the old meets and bounds boundary systems of yesteryear, in which property lines were established by vague descriptors like a stone's throw from the river or where the old church used to stand. The question whether a particular product in the real world infringes a patent claim crafted by someone, possibly years earlier, who was not even aware of the allegedly infringing product is a fraught one. And often there's no clear answer to this question until a judicial claim interpretation hearing. This indeterminacy in the system is compounded by the behavior of PAEs themselves. Often a demand letter will refer to a portfolio of patents with no clear linkage to the recipient's products. In patent litigation, we talk about claim charts that identify how every element of a patent claim is practiced by an allegedly infringing product. Claim charts are seldom included in PAE demands, and how could they be? Many of these PAE litigation campaigns target dozens or hundreds of different companies and products, and unfortunately, it's only through litigation that a patent presented by a PAE can be assessed and valued definitively. So it's not at all irrational for a company that's approached by a PAE with patents of dubious validity or infringement is uncertain to ignore the approach and allow litigation to produce a definitive result. This is, in fact, an entirely rational strategy and wholly in keeping with the law as it stands today. There is no element of lawlessness at work. Critics also complain about systemic features that enable operating companies to adopt this wait and sue approach. For example, critics of efficient infringement object vehemently to the PTAB's propensity to invalidate patent claims after they have been allowed by the PTO. And it doesn't matter that the PTAB is actually part of the PTO. This administrative body has been challenged on constitutional and administrative grounds for years, and the challenges continue. Why? Because it takes a more skeptical view of patent claims in the PTO's examiner corps, which is compensated based on the number of applications processed rather than the quality of their output. Another frequent target of these critics is the Supreme Court, whose quartet of patent eligibility decisions, Bilski, Mayo, Myriad, and Alice, have been roundly criticized for rejecting the patentability of laws of nature, naturally occurring products, and mental processes. Allegations have been made that the Supreme Court is itself acting in a lawless, or at least an ultra-virus fashion, by creating judicial exceptions to the statutory enactments of the Patent Act, a function that the court has pursued for the past 2 centuries. So I acknowledge that reasonable people can differ over optimal patent scope and policy. Likewise, the PTO and the PTAB can issue and uphold more or fewer patents, and the courts can interpret the Patent Act in ways that we like or dislike. Reasonable people can also seek change through litigation, legislation, and administrative channels. All of these mechanisms are organic parts of our tripartite legal system. We will never have a situation in which all partisan interests are equally happy with the rules or the outcome of every case, but this is just part and parcel of an adversarial legal system. It is no reason to question the legitimacy of the system itself. So far from a departure from the rule of law, what we see today in the patent system is, I think, the operation of a well-functioning legal regime seeking to address the interests of competing but largely law-abiding constituencies. And with that, I will turn the floor over to Karen Temple.
Thank you. It is a pleasure to be here today to discuss IP and the rule of law. And we're going to take a quick turn. My remarks, of course, are going to focus on that in the context of copyright law. How do clear, consistent, and strong copyright laws support the rule of law generally and economic prosperity more specifically? Of course, much of what I will say here today is pretty self-evident based on just standard basic economic principles. We know that robust and clear property rights support growth, innovation, and economic development. That is no less true in the category of intellectual property rights and specifically copyright. Way back in 1787, when the Constitutional Convention convened, the Founding Fathers knew that our culture and society benefit from creative works and that strong laws protecting those works encourage and incentivize the creation of more of them and support our overall economic development. This principle was, of course, enshrined in the United States Constitution, which recognized in the very first article the need for Congress to have that authority to develop laws to promote the progress of science and useful arts through exclusive property rights. So copyright law is the foundation of our nation's creative economy, the lifeblood of our business, and a bedrock principle that supports the livelihood of millions of American creators. Today, the U.S. copyright industries add more than $1 trillion to the national economy and support more than 5.5 million direct jobs. Our film and television industry supports 2.5 million jobs in all 50 states, as well as Puerto Rico, the Virgin Islands, and of course, here in Washington, D.C. Our movies and television shows account for $16.3 billion in exports, registering a positive trade balance with nearly every country. So I remain surprised that this is still the subject of some argument that somehow weaker IP laws or weaker IP protections and enforcement are okay or even beneficial because, well, technology or innovation. We do not need weaker IP laws or weaker copyright laws to support technology or innovation. Quite the opposite, in fact. That's why the content industries have been sounding the alarm about an unfettered technology sector for years. We have seen the unhappy results of tech exceptionalism firsthand in the unbalanced way the burden of enforcing piracy has fallen to the content industries. This is not what Congress intended by the Digital Millennium Copyright Act, and we welcome a greater adherence to the actual text of that statute supporting the rule of law. Still, many see stronger IP enforcement as a zero-sum game in which efforts to aid the copyright industries come at the expense of the technology platforms. This is wrong. When IP laws are appropriately balanced with appropriate limitations on service provider liability, both will benefit. When piracy is curtailed, content can be appropriately priced instead of artificially deflated. When this occurs, technology platforms will benefit because the content they provide will be more valuable. Many researchers, especially Walter Park at American University, have found a direct correlation between strong IP laws and overall increased GDP. This correlation is particularly strong in developing countries, but can be seen across the board. For example, a 2014 case study in India on the impact of piracy on the motion picture industry showed that increased piracy led to lower motion picture revenue and a decrease in supply for new movies in India. The study concluded that this supported a central tenet of copyright policy, that stronger and more effective copyright protection affects more creation. Similarly, a case study in 2014 of the publishing industry in Israel demonstrated that the weakening of copyright protections there after a 2007 expansion of fair use led to a smaller publishing industry than would have existed without that particular policy change. A 2015 internal study of the global motion picture industry also concluded that stronger copyright laws contribute to greater investment in new motion picture content, creating more jobs in the motion picture industry and related industries, and contributing meaningfully to a country's economy. And finally, a June 2015 study of the impact of Canada's educational sector guidelines by Price Waterhouse found that the expanded guidelines substantially reduced licensing revenue, compromised the ability of publishers to publish materials and meet varied academic needs, and that over time, the publishing of new content for K-12 schools in Canada would disappear, and the quality of the content used by school students would thereby decline. In short, they concluded, quote, fewer works will be developed by Canadian content producers, both creators and publishers, and many relatively high-paying jobs are expected to disappear. Yet despite this clear evidence of the need for stronger, not weaker IP laws, current copyright protection and enforcement in the United States still revolves around an outdated notice and takedown system in which millions of notices are sent every year and files are removed one at a time. This system is not efficient in both the colloquial and economic meanings of that term. It is not a good use of resources because content companies spend millions of dollars on content protection efforts, yet piracy persists at massive levels. It is a tax imposed on the content industry for a small amount of content protection. So what do we do about it? We need to continue to work towards stronger copyright protection in the United States and globally with all of our trading partners. In the United States, Senator Tillis, who just won re-election, is poised to continue his review and improvement of the DMCA and announced that he will be releasing draft legislation later this month or later next month. For our trading partners, we must work with them to strengthen their local copyright laws and adopt strong trade agreements. We know that in certain economies where there are fewer protections for intellectual property rights, theft is inevitable, and the negative economic consequences ripple outward. But the bottom line is this: the film, television, and streaming industry is global, whether we're talking about the content we see on the screen or the audiences watching them. And if we want to continue to thrive as an industry, we have to compete on every level, from market access to strong IP rights. And that requires strong trade agreements with strong IP chapters. These modern free trade agreements, including the USMCA, set a baseline level of IP protection that the parties to the treaty must live up to. And that baseline is almost always US law. In other words, we tell our other countries, if you want to do a trade deal with us, you have to guarantee your copyright, trademark, and patent laws are at least as good as ours. For decades, there has been bipartisan agreement in administrations of both parties and in Congress that strengthening IP laws and ensuring effective enforcement worldwide is in the vital economic interest of our country. By leveraging access to the U.S. market, the U.S. has been able to secure improvements to the IP frameworks of our trading partners. This work, of course, began in earnest with the TRIPS agreement in 1994, and today 164 countries have joined TRIPS. For copyright standards, the USMCA has also provided a significant boost. It has made the adjustments for the digital age, which include provisions on aiding and abetting for criminal copyright offenses. On the most fundamental level, it breaks down the nonsensical division between what is considered criminal in real life and what is criminal online. It includes strong rules on the presumptions of ownership, on contractual transfers, on national treatment, on criminal remedies for cable and satellite signal theft. It includes robust protections for technological protection measures similar to Section 1201 of the DMCA. And it defines commercial scale to clarify that infringing acts without a profit motive or commercial purpose are actionable. The UMCA, of course, is not a perfect agreement, but it has made meaningful improvements to the IP landscape of North America. It's the next best thing to build on. We are also making headway with China in regard to copyright protection. In January of this year, the U.S. government completed a phase 1 trade agreement, which includes meaningful enforcement obligations pertaining to copyright protection. And of course, we recently embarked on negotiations for a new trade agreement with the United Kingdom. In many ways, the UK has a more modern and nimble copyright enforcement framework than the United States. Of course, now more than ever, the stakes for the film, television, and streaming industry and many others that depend on strong IP protection couldn't be higher. So it's important that we all work together to protect and strengthen the copyright system and the rule of law it depends on. Thank you. And with that, I will turn it over to Phil Johnson.
Thank you. I too am honored to be on such a distinguished panel. It's a pleasure to be here with you and an interesting challenge to follow the excellent presentations of all three of the panelists you've heard from. Because I'm acting in the cleanup position, I'll limit myself to commenting on just a few of the things that have already been mentioned and what needs to be done or what remains to be done in order to improve our IP system. First of all, I agree that there are issues that need to be addressed, and I will start with one that I think is largely of the creation of the Supreme Court, which is a dramatic expansion of its rule that certain ideas, abstract ideas, are not patentable. In a series of decisions, the Supreme Court has taken what was a small and seldom used exception that it had in its common law and expanded it to prevent the patenting of inventions or discoveries if they're directed to, and directed to is not really defined in their decisions, abstract ideas, natural phenomena, laws of nature, and or products derived from natural materials such as isolated or purified substances. Now, of course, by having so expanded this, some things that we think of as discoveries that have traditionally been patented, such as penicillin, cannot be patented under the current precedent because penicillin is a naturally occurring substance which was isolated and purified and developed for medical uses. And there are many other areas in medicine where the same is true, especially those inventions that are based on some of our basic biological processes, which the courts have found not to be patentable recently, although they were traditionally patented. Another area of concern is that although the Constitution itself speaks to providing rights to protect discoveries, by eliminating natural products, many of those discoveries are no longer patentable. So why do we care about this? Well, we care about it not just because many people have done their research in reliance upon the availability of patent protection, have invested large sums of money to develop products that are eventually marketed. But because many people are not investing as they might because of the uncertainty that's created. A great promise of medicine going forward is personalized medicine. Almost all personalized medicine depends on the ability to understand the differences in the genetic makeup of one individual to another. In order to do that, personalized medicine relies on sophisticated diagnostics, sophisticated development of products that are tailored to someone's genome. The last thing you want is to give a drug to someone on whom that drug is not going to be effective. That can happen and does happen for most drugs. Most drugs are not 100% effective on everyone. So what you'd like to do is, with personalized medicine, is figure out which drugs are going to work on an individual and which ones aren't, which ones are the best. But we aren't able to do that as well as I think we all would like, in part because diagnostics have become essentially unpatentable. The last 10 cases that have gone to the Federal Circuit involving diagnostics have been found unpatentable by the Federal Circuit based on their interpretation of the Supreme Court precedent. This and many other factors, including public policy factors, have discouraged the development of diagnostics and have discouraged the investment into them that it takes, because it does take quite a bit of investment and many years in order to develop a good diagnostic, and actually has left us in the position that we found ourselves when COVID entered. And we found that our diagnostic capability was not what we would like it to be. It certainly wasn't, I think, now recognized in hindsight, anywhere near what we needed in order to effectively respond to the pandemic. So was this an unexpected event? I think not. By my recollection, I testified, along with many other witnesses, at least 4 times before congressional hearings, that we suffered the risk of pandemics being brought into the United States from other sources, and that we should be incentivizing the development of medical technologies, including diagnostics, in order to respond to them. But of course, now that we have a crisis, I'm thinking, and I think we're all hoping, that incentives will be restored and we will go from where we are, which is not an enviable position, to where we'd like to be, which is a leader in this area. So moving on, much has been said about inter-parties reviews and the PTAB. And I believe that the idea of the PTAB, as it was originally envisioned for conducting IPRs, was a laudable one. But as it was implemented, many things were changed. Initially, it was thought that very few IPRs would be instituted because the director would be making the decision as to whether or not to implement, and use the director's independent judgment, not based just on whether a threshold showing had been met, but also based on whether it was in the best interest of the patent system to proceed with an administrative proceeding rather than leaving the issues to the courts to resolve. When implemented, the original director at the time decided that rather than undertake this responsibility, he would simply delegate the responsibility for deciding whether to implement to the newly created Patent Trial and Appeal Board, which would in essence become prosecutor, judge, and jury for these appeals, thereby giving up on the 2-stage approach that Congress had intended. Then as implemented, the PTAB rules, the original PTAB rules, were very friendly to challengers. In the past, similar unsuccessful proceedings have been created and they weren't used. It appears that the people writing the implementing regulations decided to do everything they could to make the proceeding as friendly as possible. So these are just 2 points that we comment on. I could go on, but I see my time is up. So perhaps we'll get to them in the question and answer series. So I'll turn this back to our moderator to take it from here.
Great. Thank you so much, Phil, and all of our panelists. What I'd like to do now is open up the panel to discussions or comments between panelists. Right before we do that, though, I just wanted to remind everyone on the line of our CLE code. Our CLE password should show up in a window as well. Just to say it again, it is for CLE logging purposes. But with that, and before we move to questions from the audience, and if audience participants do have questions, just a reminder, best thing to do is to raise your hand in the Zoom box. But before we get to the audience, let's move to panelists' comments and questions between each other. Anyone on the panel, I guess we'll just go in order. Professor Epstein, I see, has his hand up. Professor Epstein, comments or questions?
Oh, thank you very much. Yes, I do have some comments, and they sort of take off on the comments that were made by George on the one hand and by Phil on the other. I think it's a kind of a synergy on the question that you have to answer is, when is it that resistance by a particular party that refuses to negotiate a deal is a good or a bad thing? The way in which it was described by George was that, well, you see these weak patents out there, they're patent assertion entities. Essentially, they just hold up operations. The appropriate model of response is to ignore them. And then if they want to come after you, you defend them. The difficulty I see with that position is the same strategy can be used with respect to very good patents that exist. And what you could say is, okay, you have to come after us. It's going to cost you a lot of money. You're not going to be able to get injunctive relief. You may have to sue us multiple times. There's nothing about a patent assertion entity which should be different from the original holder. The rights cannot be increased by assignment. They should not be reduced by assignment. And so what happens is you then have to tie into what Phil said, which is, I agree with him, as I said in my remarks, that the question as to what counts as a natural law when you're dealing with diagnostic tests and the like has been expanded all out of proportion relative to what it is. And so what happens is, now that you have these very, very weak definitions of protection, holding out against somebody who wants to sue for a diagnostic test is going to be a perfectly optimal strategy, because you're generally going to win. And so what you really have to do, I think, is to make two things. One is you have to assume that we do not want special rules with respect to PAEs. Sometimes they do good things, sometimes they do bad things, but the general common law rule, which says that the assignee takes the same rights, no more nor less, and then the original assignee is there. And then secondly, what I regard to be as a kind of a two-part program, which is extremely important, is to basically cut down by statute if necessary, because the Supreme Court seems hopeless on this issue, the definition of what counts as a natural law. And then when you get a workable definition of what counts as a diagnostic test of one kind or another, you start giving injunctive relief in order to protect it. If you put those two stages together, I think you could handle the biggest problem. I agree with Phil. I think the biggest substantive problem that we face is the expansion of the definition of what counts as a natural subject matter. And I think that the PTAB essentially has gone out of whack. The reason that happens is the same reason that always happened. You create special tribunals and give them all sorts of discretion. There's no guarantee that the first guy is going to get it right or the second guy is going to get it any better. And that the great advantage of the judicial system is it produces a kind of stability that you can't get when you have political intrigue. So I think the basic point that I made, which I think Phil reinforced, George, I think to some extent, but not hugely disagreed with it, is the more we make a patent system and a patent court system look like a regular, efficient common law system or standard adjudicative system, the better off we're likely to be.
And I'd like to just jump in, because I have a question, and I think that George is probably about to answer this in response to Professor Epstein. But I shuddered a little bit, I will be honest, when he used the word efficient and infringement together. And the concept that an efficient infringement that could potentially be applied to copyright is something that I would be very, very concerned about. And along the lines of what I think Professor Epstein alluded to, I mean, the concern would be in terms of rule of law that we would be putting a value judgment on property rights, on the type of copyright or the type of patent before we decided as to whether the rule of law would apply to that patent and a copyright. And I'm not a patent lawyer, so I can't talk about the things that were mentioned on the patent side, but on the copyright side, that would be disastrous to think that there would be some less valuable copyrights that would somehow be okay to infringe for the greater good, so to speak. So that would be a concept that I would be very, very concerned if it were applied to copyright. And would love to hear George's thoughts on.
Yeah, thanks. I mean, first, just for Ken, the term efficient infringement isn't my term. In fact, I'm arguing against that terminology. It's a riff off the efficient breach, right, which contract teachers and scholars use and have for years, and it's a pejorative term. So I don't necessarily get behind the terminology, so to speak. I mean, that being said, I do think that with patent, and I do know something about copyright. Patents, it is harder to tell what's covered by a patent than a copyright. I mean, with a copyright, you see the thing itself, you see the text, the film, you have the the encoded soundtrack, you know what that looks like. With a patent, it's lawyer's language, right, that you have to interpret. So I think it's a little harder, and so I think it's more reasonable to question someone who comes to you with a patent that, especially in areas like software, it's often quite unclear what's going on. But I'll respond to Phil and Richard a little bit. I mean, I don't entirely disagree with what they've said, but just to clarify a little bit where I think there are some points of separation. On the question of incentives, it's just hard to know, and they're difficult. They're not counterfactuals that we can look at with any great reliance, and so we don't know what's going to happen. It's interesting, Phil, that you used the example of penicillin, because the penicillin itself wasn't patented, and yet became obviously widely used. This was in the 40s, so obviously any patent would now be expired. But we can get benefits, and we can get social benefits out of inventions, even if they're not patented. And that being said, I agree that at least some of the Supreme Court's quartet of 101 and eligibility cases have either gone too far or they've been interpreted too far. And I'm particularly, it's Mayo versus Prometheus that I have the biggest problem with. And I think one of the problems, and I'm not on the Supreme Court and didn't clerk for any of the justices at the time, but one of the problems that I think we see with this natural laws area is that it just got a bad reputation due to overclaiming in years past. And so I think about the Myriad case, which I've dwelt on for far too long. Some of the claims, and this is a natural products case as opposed to a natural laws case, but in the natural products area, the claims were incredibly broad. You discover an association between 3 different mutations in a gene and breast cancer. That I think is a legitimate discovery that is probably worthy of some protection. But then to take that discovery and claim the entire gene, a gene that's over 100,000 bases long, and to claim not only the entire gene and every possible use and application of it with relation to any other disease in the world, but even something so small as any segment of that gene that's 15 bases long, right? There were claims that covered that and were allowed by the patent office. Those types of overly broad claims, when scientists look at them, and I also teach in the Department of Human Genetics here at my university, when you tell scientists about those types of claims, they can't believe it. And they say, how is that possible? It's a far cry from the actual diagnostic that originally was discovered, and which I do think there's some value in protecting. So I think to some degree the patent bar is as fault. And I was a practicing lawyer for many years, and I understand how lawyers are incentivized to draft these claims, but I don't necessarily think it's always a good thing. And to Richard's point about holdout and PAEs, it's totally right. There are good patents and there are bad patents. One thing that I think is remarkable about the United States and is good and many other countries don't have is our enhanced damages standards, right? And so if willful infringement is found, a judge can award up to triple damages in a patent case, which, again, I've done a lot of comparative work and international work. That's relatively unique, although I have to say in the Chinese patent law that was just, the amendment to the Chinese patent law that was just released, they allow quintuple damages in certain cases. So they've one-upped us. But that is a disincentive for sort of the good faith company that doesn't think they're infringing. The risk is enhanced damages. They are, and injunctive relief is still possible, even under the eBay test. You can get injunctions. It's harder as a PAE. Still possible, not beyond the realm of possibility. So anyway, I'll wrap up there. I saw Phil's hand was up. I don't want to overstep my welcome.
Okay, I'll start where you left off. What we don't have in this country that is almost universal outside the US is automatic fee shifting so that the prevailing party gets paid if they win. That would be a great remedy for some of the kinds of conduct you're talking about if you have someone bringing frivolous cases and using the transaction costs of prospective litigation as a deterrent against not taking a license, because then the accused infringer, if they were in the right, could rightly say, okay, I'll fight it out and you'll pay me my attorney's fees. And to the contrary, for cases that are meritorious, patent owners who may have trouble funding their cases will have the promise of getting their fees. I have repeatedly testified on Congress that that would be an excellent way to approach the litigation abuse that unfortunately creeps into the system. And by the way, it is not nearly as extensive in the patent law area as it is in some other areas of law, tort law. But nonetheless, I've come to understand that politically that's not acceptable to Congress because of these other areas where they don't want it starting in patent law and then creeping into tort law. So that is a concern. In most industries, the matter is handled because competitors study the patents that are issuing in the areas in which they're operating. They study the patents, they understand the technology, they study the prior art, and they get opinions so that they can shield themselves from willfulness. But I think that another fundamental issue that you raise, well, maybe I've gone on too long, but I do think that on the incentive issue, I sat for too many years on boards where we reviewed investing in whether to develop one new drug or another. And there are always uncertainties about whether you try to develop a new drug. It's a risky and expensive endeavor. But at some point during those discussions, it would come around to me as the chief IP counsel, and I would be asked, okay, if we do this, how long are we going to have exclusivity to get our investment back? And as you probably know, under Hatch-Waxman, it's no more than 5 years. But if you have a patent, it can be up to 14 years, but it's more like 9 to 12 years by the time it takes to go through everything. And on more than a few instances, I was very sad to say, I'm sorry, given the nature of this invention and given the approaches, I cannot promise you that you have any likelihood of really getting a long period of exclusivity. And as soon as I said that, the project was canceled. And these were not just incidental little formulation things. These were a new way to treat SARS, for example, a new way to treat or try to treat cancers, and so on. And you will never know, no one on this call will ever know which of their loved ones or which of their family members may have been benefited by something that hit the cutting room floor because of the uncertainty in patent protection. So when we're talking about this, which is the greater harm? The things that are never pursued and never invented and never become part of what we all enjoy? Or dealing with some of the people who are trying to abuse the system using other methods of doing that? And I'd suggest to you, we want and need to incentivize invention because we're far from having everything we need to live successfully in the future.
I guess that's back to me again, and I would like to make a couple of comments. First to Karen, I think there is a terminological clarification. The theory of efficient breach, as it's developed very poorly in my view in contracts, says you can consciously know that you're going to breach, decide to breach. Now, the other party gets his expectation damages, and you keep all the surplus, so it's a win-win situation. It never works out that way. And in your industry, what this means is usually you're not worried about derivative works, you're worried about outright pirating of existing works in their entirety. So there's no ambiguity. And so you're not dealing with any of the complexities that we're talking about when George, for example, puts it. So I think your industry, you're 100% right. The other industry, though, I think is much more difficult to figure out, which is what are you going to start to do when there's some degree of uncertainty in an industry? And on this particular point, the definitions that the Supreme Court gives are just absolute killers. And the procedural protections that they give are completely inadequate for these situations. And so I'm just going to echo what I think Phil said perfectly correctly, is the base fatal losses in the United States are the inventions that are never made or delayed because you don't get anything from them. If you get something in early and somebody else gets a monopoly turn, the monopoly return does not sop up all the surplus. This huge consumer gains, particularly in medical properties, where there's a limit of the amount of money that you could pay for saving your own life, so that the monopoly issue is not great. And we've just made the wrong trade-off on all of those things because of a kind of patent skepticism. And I think in many of these cases, if you had a more sensible system, you would be arguing about matters of claim construction. You would not be arguing about basic matters of patent eligibility. And I think that that's the way in which we have to move the world. I regard this as the single most important feature of the overall system, which is to essentially, particularly with medical and pharmaceutical patents, to get rid of these crazy definitions of what counts as a law of nature, as a natural substance, and to go back. If you recall, this last point, this exact battle came up before the 1952 Patents Act, right? And Moncalo and the stroke of genius stuff. And the Federico and Rich position was trying to go back from ridiculous standards. And I think they moved it pretty strongly, but it's only been in the last 15 to 20 years that we reverted to the way the law was between 1940, say, and 1952, which was as bad then as it is now.
If I may, patent eligibility rules aren't the way you want to sort out what should be patented and what shouldn't be patented. There are other rules that are applied in the patent office.
Yes.
Novelty.
Non-obviousness.
Non-obviousness and support under Section 112. The inventions must be described and they must be enabled sufficiently so anyone of ordinary skill in the art can make and use the same. And many of the criticisms which have been leveled at software patents, and some as we've heard today, when I've taken members of the industry aside and said, let's look at these cases, isn't your argument that it wasn't novel or it wasn't non-obvious? And the arguments we've heard today, isn't your argument that it wasn't sufficiently described and enabled? Yes, you've thrown out a lot there that you'd like to patent, but have you shown that it's new, useful, and non-obvious, and have you described it sufficiently to merit the award of a patent monopoly on it? And frankly, in heart-to-heart discussions, when I bring up the cases, some of the cases we're talking about, concessions have been made to me saying, yes, if we had it, with the system we're operating correctly, that wouldn't have been patented anyway, even if we considered the subject matter to be patentable.
With the Brock gene, to give but one illustration, the overclaiming was claiming that you had exclusive rights to the gene in situ in everybody else's body. That's just crazy. But the question as to whether you give substance protection when it's isolated and purified, that's been a battle going on since the early patents over adrenaline. And it's very hard to decide which way you want it to come out, but you'd rather have the battle on that frontier rather than on eligibility. Virtually all of these cases should be patent eligible. And then the question is, which of these three increments go? And the Brock gene was classic overclaiming, I think, just as George said, for those particular reasons. But I think if somebody wants to take it and then use it as a therapeutic device, I find very hard to say that there ought to be any kind of categorical bar against that particular development.
And I would add that what we're talking about in the medical area is not getting injunctions. There is still a public benefit exception as an equitable bar against injunctions when that is in the public interest. And in fact, most of the major pharmaceutical companies, when you're talking about serious medical treatments for which there's not an equivalent substitute, do not even try to get injunctions. And in the diagnostic situation with a pandemic, you would never try to get an injunction. It's adequate in those situations to provide reasonable royalty or lost profits to the patent owner and not deprive the public of the fruits of the inventions.
But that's the way you announce it going up, right? You give non-exclusive licenses.
Right.
So, I mean, you never claim it, so you don't have to worry about it. And, you know, that was always the case. For example, when Lilly came out with insulin for the first time around, it used to give it out for free to people who couldn't afford it.
But, you know, it's not widely recognized, but the pharmaceutical industry pays hundreds of millions of dollars a year in royalties to universities and other sources of some of the inventions that the pharmaceutical companies have taken in and spent, in turn, billions of dollars developing for marketing. So licensing of rights is fundamental to the ability to develop technologies in all industries.
Yeah, I actually don't disagree with much of this. I mean, Phil raised fee shifting a while ago. I 100% agree with that. That I think is a very sensible rule that you know, actually has been litigated in the U.S. Recently, but without great effect. But you know, on the bigger question, on this 101 versus, you know, sort of patent eligibility versus the other stuff, anticipation, non-obviousness, enablement. I think this is right to a large degree. You know, the adrenaline case is definitely one of the you know, one of the bugaboos here. One of, I think, a low point in learned hand's early judicial career, right? And I mean, the problem with the way many of these substance patents are drafted in claiming the thing, the product of nature, as opposed to its use to diagnose or cure a particular disease, is that you preempt all of the uses that you never even thought of and didn't know anything about by claiming the thing itself, which is odd, and it seems just intuitively wrong when you discover the mushroom out in the forest that no one had ever found before. If you find that the mushroom is a great, you know, you can apply it to your burns and it will make them go away, and you claim it as a burn treatment, that's great, that should be allowed. But to claim the mushroom itself for every other purpose, which is how many of these claims are written, it kind of shocks people who look at it afresh, who haven't been, you know, steeped in the patent world, and that causes a bad overreaction in some cases.
But you don't need to, excuse me, you don't need to get rid of that problem by making all uses of mushrooms unpatentable. no one is going to go out and successfully patent a gene as it exists in vivo in the human body, or a mushroom as it exists in the forest. That those are traditionally not patentable, and not because of eligibility rules, but because there's prior art. Mushrooms are known, genes are known.
I think it's eligibility to some extent. The natural substances. It's when you convert them or isolate them. And the problem with the isolation and purification standard is actually very difficult. If you only give them a procedure, it's a very weak protection, because it's sometimes very easy, we've seen one procedure to invent another. On the other hand, if you give a substance protection, it could turn out to be too strong, because somebody with a wholly novel alternative will be blocked. And so it's either a question of too little or too much protection. And I don't see any way to resolve that question conclusively for all projects at all times and all periods.
If the Constitution provides protection for discoveries, and the statutes provide protection for discoveries and inventions. So if you were the first to go out and discover something, even if it exists in nature, under the Constitution and the laws, assuming you could meet the other criteria, it would be presumptively patentable.
You would think that you could patent radium because you're the first person to isolate it or discover it?
If no one had ever heard of it before, I don't know. It's
Boy, I'd be very, I mean, I know the word discovery, but I tend to think of it not as finding something that you've never seen before.
Well,
I think of it as basically.
Well, it's not something that you've never seen before. That's not the test.
I know, it's got to be stuffer.
That's not the test. If you are the very first person there, let's say there is a molecule somewhere no one has discovered, and you go find it, and you then isolate it, purify it, and use it and to successfully treat cancer, that has traditionally been patentable until the last 10 years.
I agree with that, but you've got the second two stages on the first.
Well, it's P.J. Federico, I think,
Yes.
said, thing under the sun that's made by man, right?
Yeah, no, I'm not saying it's wrong, but I'm saying it's all the things. It's like adrenaline. It's precisely because it was isolated, purified, and used.
But let me defend the patent attorneys for a minute. The patent attorneys have the job of representing their client, writing the patent, doing the best job they can, and writing claims. It's the patent office whose job it is to look at the claims and examine the claims and decide which claims are patentable. Don't blame the patent attorneys for asking, blame the patent office for granting it. But once the patent office grants it, then there is some presumption that they've done the job right. And if you don't like how they're doing, then what we should be talking about is increasing the funding for the patent office. Because the worst thing in the world is to have an illusory right and have people lose all confidence in the patent system. What you don't want is having the patent examiners using one standard, and then after people have invested hundreds of millions of dollars or more in order to develop and market the invention, have a PTAB come in and say, oh, well, we don't use that standard. We have our own standard, and now it's invalid. That pulls the rug out from people who relied on the patent system, and they are learning already that if they have money to invest, maybe they ought to put it in developing content for Netflix rather than doing the next cure for what might ail you.
Yeah,
I don't disagree with that at all. Like I said, the motives for patent lawyers are perfectly clear, and they're motivated by what the system gives them. And I agree, the patent office is really where the rubber hits the road here. And a number of directors have included patent quality, whatever that means, as one of their goals in improving the examination system. But you're totally right. In a system where you're compensated based on throughput and output rather than any kind of indicia of quality, which who would even know how to measure it? It's tough. But I want to come back to discovery, because what you said about discovery is absolutely right. It's in the Constitution. It's in the statute. I think the question is, like, what did you discover? Right? You go into the rainforest, you find the mushroom that no human eyes have ever seen before. And then you realize that the mushroom juice will cure your burns. You discovered a cure for burns using the mushroom, but did you discover the mushroom, right? Is the language of the constitutional clause intended to give you the right to claim all uses of the thing just because you were the first, not to create it? This isn't made by man, right? This is something that you just found in nature. I think there's not nearly enough analysis of what discovery means in this context.
And then the answer there is that the Patent Office, as you know, has thousands of examiners. And these examiners, many of them spend their entire careers specializing in particular art units, particular subcategories of technology. And they are the ones that we rely on primarily to look at a disclosure and decide whether it's new, useful, and non-obvious, and whether it's sufficiently described and enabled. So we're relying on them. They're the experts. The PTAB judges, while they often have some technical training, are not experts in the technology. They don't have the expertise. And so they do the best that they can. I'm not saying they're bright people and they're motivated and so on, but the question is, who are we going to rely upon? The experts who have no axe to grind, who are examining patent applications with their expertise, or somebody else? Now, traditionally, the somebody else has been the courts. And the advantage of going to the courts is that you can have a full trial. You can hear from the inventor, you can hear from experts with live testimony, with live cross-examination before the trier of fact, and you can subpoena witnesses if you don't have the witnesses you need, and you can have a full exposition. It's not cheap, it takes some time, but I think those people who are familiar with litigating regularly will tell you, yeah, I've won some I shouldn't have, I've lost some, but generally they get it pretty much right. The problem with the PTAB is they do it on a cold record. They don't hear, you never have a witness testify live in front of the PTAB panel. They don't even have experts being presented live. Anyone who's been in a trial will tell you, you can't reliably decide on a cold record. Once you see the demeanor of the witness and so on, that means everything. And yet we don't have that. And even in cases where it would not be clear to most people, the PTAB thinks nothing of striking down, or in some cases upholding them. And that is undermining confidence of the users in the system.
Well,
and that is not good for the rule of law.
I think you should have more questions.
Thank you, Phil, and thank you everyone for a great discussion amongst the panelists. I'd like to open things up to the audience for a couple questions. A great discussion also of mushrooms, and I note that mushrooms, hallucinogenic mushrooms, I think are now legal in Washington, D.C. after the last election, which is a good segue to remind everyone that our panel after this at 3:45 is modern quandaries of law enforcement. So keep that on your schedule. But this panel runs until 3:30, and I'd like to have 15 minutes to open things up to the audience. Our first question will open things up to Professor Dimitri Karstad. But I'll just remind everyone before we turn over to Professor Karstad for a question that our CLE password is, which should appear on your screen right now. If you have a question, please raise your hand with the Zoom button, or if you're on a telephone, dial *9. And now our first question, and remember, if you're asking a question to unmute your phone. We have a question from Professor Karstad.
So I guess you can see the video. You can see, maybe you can hear me. Thanks so much for this great panel. Really enjoyed it. My question is maybe to George and Phil, but really to all the panelists. That's about the PTAB. So one of the complaints about the PTAB has been that it allows for executive branch actors to pick winners and losers in bad litigation. And with the change of administration, I've seen a move to much from a defendant-friendly or perceived defendant-friendly system to a much more plaintiff-friendly PTAB, to the point that the big tech filed a long-shot lawsuit challenging discretionary IPR denials. In addition, there was a recent PTAB decision called RPX versus Applications in Internet Time, in which the doctor put the chief APJ, deputy chief APJ, and vice chief APJ on the panel after the hearing. So different panel was basically the original panel was replaced, which promptly reached a pro-plaintiff result on a very important issue of real party and interest. So my question is, are these kinds of developments a feature or a bug of the current PTAB system?
Bad in general. I mean, I couldn't quite hear everything that you wanted to say, but I'll make this one simple observation. Administration is an enormous disadvantage associated with the PTAB, because you could begin in one administration, you get changes, and then you get changes in the bench. The federal judiciary is much more continuous, and if it turns out you think expertise is a real issue, then you think of Article I courts. Don't think of the PTAB, would be my general resolve.
Yeah, I would just, and Dimitri, it was a little hard to understand the audio on that, but I mean, I would say I think that the PTAB is you know, it's one of these live and learn situations. Certainly things have changed, right? The statistics that you see about reversals and initiation have evolved since 2013. And, you know, the cases come out both ways. I don't, Phil mentioned the cost differential between a PTAB proceeding and full-scale litigation in a federal court. It is at least an order of magnitude difference, right? It's a huge difference. And, you know, that's important. So you do lose some of the procedural mechanisms that you have in district courts, such as live witnesses and testimony and experts and so forth. But you gain efficiency, and you gain, you know, something that's sort of in between. And I don't think that inherently or constitutionally that's a bad thing. You know, but I also agree that there are problems and flaws, and it should incrementally be fixed, right? These issues, these flaws should gradually be fixed. But I disagree with the people who say we should throw out the whole PTAB as unconstitutional and just go back to, you know, examination and district court.
On the other side of that debate, I think scrap it and go back to the traditional system.
Well, traditionally, what the predecessor board did was it decided patent interferences and some other things. And under Section 146, if a party was aggrieved with the board's decision, the party could appeal directly to the district court and request even a trial de novo if it was appropriate. Frequently that didn't happen, but especially in cases where witnesses were unavailable to the aggrieved party in the patent office proceeding, then they could be subpoenaed and brought in court. And this system worked, I believe, in one form or another from about 1830 on, where patentees always had the opportunity to take their grievances to the courts. This was written out in the American Invents Act for the PTAB, but many people believe that if the decisions of the PTAB could be appealed to a district court for district court review, it would not only fix what we call the Arthrex problem, which is the apparent unconstitutionality of the PTAB judges, but also provide judicial input that would be used then by the PTAB to improve its own processes. And we would evolve to a much better system much faster.
Next question.
Excellent. Well, thank you for a great question. So we'll move to next question from the audience, Stephen M. And just a reminder, as you ask a question, Stephen M., please take yourself off mute. Go ahead with your question.
Thanks, Judge Holt. This is Steve Tepp. Sorry, I guess I didn't have my name entered properly. I want to follow up on Register Temple's and Professor Epstein's comments about the so-called efficient infringement in the copyright context, because it's not hypothetical. Right now, pending before the Supreme Court is a copyright infringement case, Google versus Oracle, in which it's undisputed that Google was offered but refused a license and went ahead and copied verbatim over 11,000 lines of Oracle's code in order to build its famous Android platform. Google has explicitly argued to the court that Oracle's copyright rights should not be enforced in order to allow Google to engage in what it calls efficient infringement. So I wonder, based on the comments so far, if we can all agree that the notion of efficient infringement does not belong in copyright and that this argument does not offer a justifiable basis to set aside the rule of law on policy grounds. Thank you.
No brainer. I mean, Google's always been a predator in that regard. And it seems to me what Karen is going to say, and I'll let her say it in a second, is that if you know it's a deliberate infringement, it doesn't matter whether you're talking about Gone with the Wind or a bunch of code, so long as the thing is protected. Either you invent around or you purchase. And what Google is saying, we can get it for less. And it's not even clear what measure of damages they would want. I think their view about efficient breach, correct me if I'm wrong, Steve, is that you don't get any damages because we're so socially virtuous that you shouldn't have to pay anything. Or are they willing to pay some kind of a license? Could you clarify that for us?
I think Steve is off the line now, but with that warm up, we'll hand things over to Karen.
Yes.
Yeah, and I think the argument is that they shouldn't have to pay anything.
God help us, yes.
Yeah. If it's a fair use, or then there is no requirement to pay a license, and that's why, yes, I did shudder in terms of the attempt to try to bring some of these patent concepts into the copyright field, which is, I think, very, very different, as you all pointed out. But unfortunately, we do see that bleeding, I would say. I mean, we also had mentioned the patent trolling, and the notion somehow that more enforcement or the use of our laws should indicate something is wrong with our laws and we should weaken them. And that has bled into the copyright realm as well, where people are now starting to talk about copyright trolling, which I think is very, very overblown, but using that concept of patent trolling to say, well, yes, that's occurring in the copyright realm as well, and therefore we should weaken the laws because people are using the laws appropriately to protect themselves. And so I think that's a camel in the tent, so to speak, concept that is very dangerous for us, because once you start suggesting that use of the laws and enforcement of the laws suggests something negative and that you should weaken them, then I think, again, going to the title of this panel, the overall rule of law gets weakened. And so that's certainly a concern in the copyright space as well.
The one comment, the fair use doctrine is perfectly legitimate to take a piece of work which you wish to comment, that you should be able to quote what you wish to criticize. But nobody's doing an intellectual critique of the code. They're just simply using it. And so it doesn't make for more efficient public discourse about literary works in this case. It's simply an outright form of theft. And they're saying it's okay to steal because it wasn't 12,000 lines of code. It was only 11.
And I would say, I mean, adding to that, I mean, there's just the way that courts have interpreted fair use, even more broadly. And so we've seen, recent debates about what is transformative use and arguments that just taking something from one media to another is somehow transformative. And so that should be a fair use. And so we're, again, yes, I completely agree with Richard that fair use is a legitimate doctrine, obviously, and it's a core aspect of our copyright system. But we see and have seen, I think, in many recent years, courts taking that too far because they've been concerned somehow that, there will be this suppression of innovation and technology if, fair use is not dominant, so to speak. And so I think that's dangerous as well, because it takes fair use beyond the boundaries that it really was supposed to be, and it essentially creates a complete exception without actually weighing in the factors that the fair use doctrine is supposed to weigh, and just kind of relying, for example, on the term transformative, and then people arguing that almost anything is transformative, which is, again, I think somewhat dangerous for the rule of law and how we want the copyright system to evolve.
Amen.
So we still have 5 minutes left, so would like to have at least one more question, if not a couple more from the audience. I see a hand up from Professor Greg Dolan, Professor of Law at the University of Baltimore, as well as a justice on the Supreme Court of Palau. I'm not sure what part of the globe Professor Justice Dolan is calling in from, but question for the panel?
Thank you, Judge Holt. Sadly, I'm calling from New Jersey because Palau has closed its border due to COVID, and I'm sort of stuck here and doing my work remotely. I would much rather be on a beach, but the panel is sufficiently exciting for me not to complain too much. So the question, actually, I wanted to follow up on Professor Karstad's question, and perhaps it's somewhat of a splitting of the difference. So I take Professor Contreras' point, and I think I completely agree with it in some sense, that there's nothing inherently wrong when somebody comes to you and says to you that I have legal right X, and you're saying, well, no, you don't, and I'm going to challenge it and so prove it that you have legal right X, whether it comes to patent enforcement or whether it comes to post-traffic accident where you say, look, it was your fault, and you say, well, no, prove it, I'm not going to pay you until you actually win in court. I think that's, or irregular property trespass, when it's like, no, your line is not there. So I think there's not that in and of itself, I don't think undermines rule of law. And so my question is more along the lines of what do you think that there is a danger to the rule of law in terms of consistency of application that we have with so much being assigned to PTAB, which is ultimately under administration's control, where we have actually seen it that with the change from the Obama to Trump administration, PTAB and PTO has started behaving very differently, and who knows what is going to happen if and when Vice President Biden's when it's confirmed and he appoints his people, and then 4 years from now, somebody else was going to come into the Oval Office. And it seems to me that generally when we talk about dangers to the rule of law in the world, we generally talk about that the law or the enforcement very much changes based on who's sitting at the executive mansion. And if that's true here, it's not so much that people are forcing you to go to the courts, is that they're forcing you to go to the courts based on what they think they can get from a given administration. Do you think that's more of a problem?
Okay, look, I'm going to take a crack at this. Is the Chevron problem writ large. What happens is you give enormous discretion to administrative agencies on questions of law, then flip-flops are going to be the order of the day, and the courts themselves will not be there. And so what you need on that case is to basically make all questions of law questions of de novo review. Now, also, by the way, I just want to take the moment, thank you, Greg, for the piece that you wrote on medical patents, because I think it showed pretty conclusively that the quality of these patents, taken as an average rather than looking at some exotic examples, is much stronger than was commonly claimed. And I think that that should be the baseline for this discussion, rather than the assumption that these are uniformly or often very weak patents. So I just wanted to give you a thank you for the article you wrote. I guess it's what, about 5 or 6 years ago now?
Thank you.
Sure.
So I thank Greg for the question. I think it's an inevitable reality of the world that the administration in the seat of power in any government is going to have an influence over people both appointed to administrative tribunals, but also to the judiciary, right? As we've heard extensively over the last year, the president of the administration can have an influence over who's appointed to the judiciary, and that's actually a feature in the eyes of many as opposed to a bug. So I don't know. I think that's something that we can live with, right? And the answer is democracy, and you don't like what this administration is doing, vote in a new administration, and then the people who are more aligned with you will be appointed. I mean, I think that's quite explicit in the discourse today.
But the objection is not to this or that administration, it's to unnecessary transfers, and you get greater continuity through judicial interpretation of law under de novo standard. It's not an argument I like Trump or Biden or anybody. It's an argument for continuity, and everywhere else in the law, questions of law are decided by judges. Why at this point would you not want to do that? I think that's the final word that I'm going to say, and I will now be quiet.
Thank you, Professor Epstein, and yeah, we'll have final comments and notes on that from Phil, and then Karen, and then we'll have to wrap up. Go ahead, Phil.
I'd like to comment on the need for certainty over the long term. When you're deciding whether to invest in developing a new product, which may take you 3 to 12 years to do, and that question comes around the table as to whether to do that project to the patent attorney, you don't want the patent attorney to say, well, I don't know, it's going to depend on who the president is 10 years from now when you introduce this product, or 15 years from now when it gets successful. That's not the way a functioning system works. What you want is to say, no, this is going to be a piece of property. We can, depending on what the patent office grants us, we can rely on this, and you can invest heavily in trying to develop it further and doing further research because you can count on it. And having it fluctuate every 4 years or 8 years is just not the way the system should work. We need the courts to provide more stability. The judges are appointed for life. They interpret the law and apply it, and they aren't involved in enough of these so that any given judge is going to upset the system. You'll get a more predictable average. Thank you.
And I would just add just on the copyright nuance to this, really not specifically with respect to kind of consistency in terms of administration, because that doesn't apply to the Copyright Office, but just in terms of consistency and the ability for the Copyright Office to be able to meet the technological advancements that we continually see. And so one of the things that the Copyright Office, I think, in the past has discussed, and it's been a issue of debate, is whether that office should have more regulatory authority to be able to, address new changes in technology more so than they do now. They have a lot less regulatory authority than the Patent and Trademark Office does, and so that has been a question, I think, for some time. And one of the things that we would want to deal with, whether there should be more regulatory authority in the Copyright Office to be able to make changes that will not be able to be made quickly through the legislative process. Although it sounds like with some of the concerns I've heard from this panel, there might be some concerns in terms of giving that an agency more authority over these issues. But certainly that's an issue I think does need to be addressed, and whether there's a way to keep up the copyright laws with the technological changes without having to do it through the legislature, but having it done more through the executive branch through the legislative branch, through the Copyright Office itself.
Great. Well, thank you so much for a wonderful panel. Quick final reminder, the CLE password for our panel is a big thank you to our panelists as well as the audience and those who asked questions especially. A big thank you to any veterans who might have been listening in. Thank you very much, as it is Veterans Day. And with that, a reminder that the next convention event is at 3:45, so a little bit over 10 minutes from now, a discussion of modern quandaries of law enforcement to hopefully pick up on the mushroom discussion. And with that, we will end this panel. Thank you to everyone.